right, so this is Chapter 17, Wills and Estates. So, you may be wondering why are we talking about wills and estates, and this is real estate law class, right? Well, title to real property can be acquired through a will. It can also be acquired through intestate succession, or what happens when you die without a will. And for that reason, you need to have a little bit of knowledge with respect to wills and estates and how the transfer of property is handled with a will or if you die intestate. So here are the basics, and that's what we're going to cover today. So if a person dies without a will, he or she is said to die intestate. And you have to know that term for the next test, so just in case you want to make yourself a little note. And so if you die without a will, property is disposed of according to the laws of the state where the deceased last lived. So some people think, oh, well, if you die without a will, the property automatically escheats to the state. It does not. And we'll talk a little bit about the Virginia intestate succession statute towards the end of today's class. The other term you have to know is testate. So if you die with a will, you die testate. So testate simply means to execute a valid will. And in Virginia, to execute a valid will, you must be at least 18. By the way, you have to know that for the test. And an attested will, that's one that's witnessed, is going to have 2 witnesses. And you have to have the requisite mental capacity to execute a will. We'll talk about one case today dealing with mental capacity. And actually, kind of spoiler alert, we'll see that they did not have mental capacity. So here are the types of wills that we have in Virginia. The first type of will is what you think of as maybe a lawyer's will. It's an attested will. Again, it has 2 witnesses. It has a testator, that's the person who writes the will, who has mental capacity, and they're at least 18 years old. There's another kind of will that you may never have heard of. I know I hadn't heard of this until I went to law school, and it's called a holographic will. And this is an example of a holographic will. And it's simply one that's all in your own handwriting. You don't have to have any witnesses, but the absolute must, it must be all in the testator's handwriting. We've had cases where people have had printed addresses at the top, or maybe they're disposing of a piece of property and the property has a name, and so instead of writing in the name of the property, they use a stamp. Those things would invalidate a holographic will because it's not all in the testator's handwriting. And then the last type of will that you have is very rare, and actually this kind of will does not convey real property. It's a sailor and soldier's will. It's an oral will, and it may only dispose of personal property, not real property, and it's made during a time of war by service personnel. All right, so let's consider the following. So this is supposed to be a holographic will. Actually, it was a holographic will. So the following language was found in a holographic will left in the residence of William P. Avery and Deborah Smalling, who were unmarried, but lived together in the house they had built with their earnings and savings. And this is what it says. I would like Deborah to have my home and property to maintain and keep, with the hope that she may find the comfort and independence that she has been denied me. That has been denied me. She has been my love and faithful consort and has given me untold support and happiness. Words fail me. Signed, William P. Avery. All right, so this is consider 17.5 in your book. Now, when you see this, if you're not a lawyer and you write a will, oftentimes there are problems with it. So to you, as a layperson, does this look like a will? You know, I could leave a piece of paper that says this. I would love for my children to grow up and to have a house that is comfortable and paid for and blah, blah, blah. Is that a will? No. Okay, so look at these words. Does this look like a will to you? I would like. Anybody think it looks like a will? All right, so this was litigated, and so here's my guess too, that they probably spent the entire value of the estate on lawyers, because it is not cheap to litigate something like this. And so does the language, does this qualify as a holographic will? Well, it's all in his own handwriting, but it doesn't say it's a will. And he just says, I would like. It doesn't say, I hereby bequeath, well, I hereby, this is my last will and testament, I hereby give to blah, blah, blah. Holographic will? No, it's not. And so does the language have any ambiguities? Yeah, well, it is a little bit ambiguous, right? Because he doesn't say, this is my last will and testament. He just says, I would like to have my home and property. I would like Deborah to have my home and property to maintain and keep. Yeah, well, I'd like to have a Rolls Royce and a, no, I really don't. Let me drive my smart car any day. I'm good with that. But anyway, yeah, it has lots of ambiguities. With the will pass Deborah the 32 acres of land on which the house sat. And it doesn't say anything about that, does it? The land, it just says the house. So even if she got a really generous probate judge and he said, yep, you can have the house, but only the dirt underneath it. Anyway, lots of problems with this. And this is common with holographic wills, is that they have lots of problems. So I don't suggest that you do this. Have I written holographic wills before? Yep, many times. Usually I'm sitting at an airport getting ready to get on a plane when I write one of these for myself. And then I mail it to myself, hoping, of course, that the plane doesn't crash. That was when I had little kids. Now I don't worry so much, you know. If I beam up, I'm good. But anyway, lots of problems. The problem with property is property includes real property, personal property, intellectual, a lot of different things. So it's ambiguous. We really don't know. And what if he had other property other than this? So anyway, it didn't fly. All right, so here is a problem. You know, I said to have a valid will, you have to have mental capacity. Here's a problem where there may not be mental capacity here, and certainly there was a family squabble without a doubt. And the case was Bracewell versus Bracewell. And if you look at the bottom of page 457, the bottom of the first column, then you can see a pretty good discussion about testamentary capacity. Anyway, Irene and W.T. were married, and they had 2 sons, Bobby and Charles. So Irene executed a will, and she left everything to her husband, W.T. In the 1970s, Irene had a plethora of health problems, and she was taking numerous narcotics for these health problems. 1989, so you know, almost 2 decades later, W.T., the husband, executed a will, leaving everything to one son, Bobby, and cutting out Charles. So Irene decided that she was going to retaliate, and she was going to write another will that left everything to Charles, the one that W.T. was going to cut out. Irene dies. There's an attempt to probate both wills, both the original will where she left everything to the husband and the subsequent will where she left everything to the son. And the question for the court is, did Irene have testamentary capacity? And so if you look at the first column at the bottom of page 457, you'll see a discussion of testamentary capacity. And Irene was on many narcotics, and she was in poor health when she executed the second will. And the court in this case decided that they were not going to grant her testamentary capacity, and that she was not going to be able to write the second will. So here's just a few of the things that she was on. She had been prescribed Librium to treat her anxiety, diazepam, which is a relative of Valium. She was also on Sinequan, which is described as a major tranquilizer. And she had been prescribed Valium in addition. Anyway, she was on too much stuff to have testamentary capacity the second time. And so the second will is not valid because she lacks testamentary capacity. Hopefully the dad did the right thing in the end and split it between the 2 boys. I don't know. Okay, so So some terms that you need to know, just a few. And so this is actually what a codicil to a will would look like. Is this on the next test? And the answer is yeah, it is. A codicil is one of the terms that you have to know, and a codicil is just a written document that amends a will. That's all it is, and that's an example of a codicil. So if you wanted to change your will, you don't have to write a completely new one. You could just write a codicil and change a certain provision in it. So here's some terms you need to know. Testator is the person who leaves a will. I don't know if they still make that distinguish between a testator and a testatrix in this time of being woke, but anyway. It used to be that a female who wrote a will is called a testatrix. So just in case you ever see that word, maybe they've eliminated that from Webster's dictionary, I don't know. A beneficiary is a person who's given property. So if you've been given property under a will, you're a beneficiary. The estate is just the property left by the person who died. A codicil is, right here on this slide. And you could have a specific devise or you could have a general devise, specific devise. So this is what it would be. I leave my 1981 Fiat Spider to my son Rip. That's specific. General devise. I leave my property manager in the Bahamas $1,000. And so that would be a general devise. The next slide, unless you go to law school, you don't really need to know this, but I suppose it's in the book, and I thought, well, we'll look at it anyway. And property may be left to, under a will, either per capita or per stirpes. Per capita means by the head, and per stirpes means by the line. And so let's say that my grandmother had she had like 8 grandchildren. She had 4 boys. They didn't all have an equal number of children. One boy had 3, one boy had 2 children, one boy had 2, and another had 1. I don't know if that even adds up to 8, but anyway, they didn't have an equal number of children. If she wanted to leave property to her grandchildren per capita, we would all get an equal amount. If she wanted to leave property to us as grandchildren per stirpes or by the line, we would receive what our parents would have received. In other words, so there are 4 boys. So I had a brother and a sister. So there were 3 children in my dad's line. So the 3 of us would share 1/4 of the estate. Now his brother had 2 sons, and those 2 boys would share his 1/4 of the estate. And then I had another uncle who only had 1 daughter, so she would get 1/4. So it's by the line and not by the head if it's per stirpes. All right, so let's look at this real quick. 17.3. So H and W were married in 1949, and they had 4 children, A, B, C, and D. H died in 1990 and left all of his property to W, the wife. Wife passed away 2 months ago, intestate, so without a will. A died in 1989, but had 3 children, X, Y, and Z. B, C, and D are still alive at the time of W's death. B has 1 child. R and C both have 2 children, T and S. How would the property be distributed in your state? Okay, so in our state, the way we would do it is this, and we have not adopted the Uniform Probate Code if you went back and read the chapter, but in our state, X, Y, and Z each get, they split 1/4. X, Y, and Z. Yeah, each split 1/4. B gets X, Y, and Z. Where? Yeah, X, Y, and Z. B gets B's child R. No, B has 2 children. No, B has 1 child. B's child R gets 1/4, and then C has 2 children, and C's 2 children each share 1/4. Anyway, so it would be the presumption is. Per stirpes, that's the presumption in Virginia, or by the line, okay? So the property would be distributed per stirpes distribution under the Uniform Probate Code also, so the same way. But we do not, we never adopted that in Virginia, but Virginia law provides for the same thing. Okay? Was that clear enough? That wasn't, was it? It doesn't matter. I'm not going to test you on it, but if you go to law school, you'll probably spend a week talking about probate law and per stirpes versus per capita distribution. All right, so here's one question that's on the test. What property is not disposed of by a will? And so you should realize this, that property held as joint tenants or tenants by the entirety is not distributed according to a will. It passes outside the will. In fact, oftentimes, holding your real property this way is a substitute for probate. And a lot of people intentionally do that. The other thing you need to remember is that life insurance that is paid to a named beneficiary is not distributed according to the will. And so not only is it not distributed according to the will, what I've seen is people who try to change the beneficiary of a life insurance policy by making a provision in a will. You cannot do it that way. Cannot be done. It must be on the form with the insurance company, okay? All right, so how do you revoke a will? Well, there are lots of different ways to revoke a will, but one way that you could revoke a will is by physical act, by tearing it up. Of course, the problem is this, or by burning it or shredding it is a good way. The problem is this, we've had cases where it was ambiguous as to whether someone intended to revoke a will by destroying it. So we've had a case in Virginia where a will was found and it had been cut into, not paper dolls, but I don't know how to do this, and I've never done it, but where you pull out a chain and it looks like dolls, you know. They'd folded it and made anyway, and the question was, did they intentionally do that? Is it a revocation of the will? Probably the best way to revoke a will would be by subsequent instrument. So in other words, the first thing you do, the first line of a new will is that, you know, I hereby revoke all other wills hereby made by me. And so you'd have a revocation sentence at the very beginning. And then the last thing I need to tell you is that divorce. So if you have a valid will, and after executing that valid will, you then divorce revokes the provisions in the will as to the ex-spouse. Okay? All right, some miscellaneous situations. All right, so you have to know this for the test. Adopted children in Virginia take just like a natural child of a person. So if I adopt a child, my adopted child is treated just like one of my natural children for inheritance purposes. But here's the other thing in Virginia, and this varies from state to state, and that is once a child is adopted, he or she is cut off from inheriting from their natural parents. And we're going to look at a case in a minute where you'll have to apply that, but it's in a state that has a different law. The exception to the rule is this: if there's been a divorce and the new parent adopts the child, then in Virginia, the child can still inherit from the biological parent. Now, I'll tell you too, this is extremely difficult for the new parent to adopt the child. The only way that could happen is that if parental rights have been terminated, or mostly the way it happens is if the other spouse agrees. And that almost never happens. And then the last thing is this: murder. Conviction of murder bars participation in the estate. Conviction of murder would mean that you also cannot inherit from someone. So, and if you are the named beneficiary in a life insurance policy, you cannot, you can't be the beneficiary of a life insurance policy. All right, so y'all have had me as a professor over the years, and you know that one of my former law partners, or someone I practiced law with in Farmville, murdered his wife. And right before he murdered his wife, or just months before that, he was up to his eyeballs in debt. He took out a life insurance policy on her life, named himself as the beneficiary. He killed her, and then he tried to collect on the insurance policy. Is he able to do that? Absolutely not. Absolutely not, yeah. So if y'all have a Prime video account, so Amazon Prime, it's actually on there right now if you want to look at it. Have you ever seen the show The New Detectives? It's kind of an obscure show. It's free. Anyway, season 6, episode 1. Season 6, episode 1, and it's the middle story. And it's a Farmville story. It's the Farmville murder story. But anyway. Conviction of murder bars participation in the estate. Also, you cannot be the beneficiary of an insurance policy. All right, so here's a weird one. Here's a case. The Vanderveens had 2 children, Kent and Laura. Kent murdered his parents. Okay, so is he going to be able to take under their estate? No. Okay, so the will, his parents' will, left the estate to the 2 children per stirpes, which means each one would get half. Per capita would be the same result. Each would get half. Kent had fathered a child out of wedlock. That child had been adopted, legally adopted by another couple. Nobody knew of it until after this happened. Okay? So, what is a slayer statute? So a slayer statute would say this, that an heir who is wholly innocent should be able to inherit. And so here, Kent's child, who is wholly innocent, the child had nothing to do with the slaying the parents, should be able to take Kent's share. That's all it is. That's the slayer statute. Okay, but in Virginia, it would be a little bit more complicated, because in Virginia, what would happen is that since the child was adopted by another family, we wouldn't allow the child to inherit from the father, from the biological father. All right, so second question, what does the court find about adopted children inheriting from their biological parents? Well, it really doesn't matter. In this case, they don't have the same sort of law that we do in Virginia, but let's assume it's in Virginia. So in Virginia, the child wouldn't be able to inherit from the father anyway, because the child was adopted and does not fall under the exception that we recognize. All right, so Laura's position is very different. Laura is the sister. Her position is very different from what it would have been had if the inheritance to the grandchild had been allowed. Yeah. So instead, in Virginia, Laura would get it all. In the state in which they live, in this real case that was in the book, in this case, the state allowed Kent's child to inherit Kent's share because they had a slayer statute, and they didn't have the same prohibition of inheriting from your biological parents once you've been adopted. All right, a lapsed gift. All right, so if someone named in a will dies before the testator, the person who wrote the will, then their interest fails unless they are survived by a child or a descendant of a deceased child. Got it? All right, so another thing that you should be aware of, do you want me to explain that, or do you all understand that? You good? Okay. Simultaneous death. And you can take a look at the simultaneous death statute on page 453. But under the Uniform Probate Code, again, we don't have that, but we have the same provision in Virginia that they have. With a simultaneous death, you must survive 120 hours before you're allowed to inherit. Okay, so this is the gruesome situation that I always considered. My husband and I first got married. Actually, we didn't have enough money to fight over anyway. We had $0. But, so we have no children. What if we die in a common car wreck? We're both in the same car. We die in a car wreck. And let's say I survive 10 minutes longer than he does. Does all of his property go to me, which wasn't much anyway? Does it go to me and then go to my side of the family, or not? Well, the statute kind of clears that up. To be able to claim that you are a survivor, you have to survive 120 hours before you're allowed to inherit. So that makes the situation a little bit easier in terms of deciding who gets what. But I know this whole will thing is kind of gruesome to think about. All right, this term probate, and if you wanted to look at the probate procedure in Virginia, I gave you the link to our probate resources. But anyway, probate is simply the orderly disposition of property. Debts and expenses are paid and the beneficiaries receive their property. You're going to file the will in the correct court, and you have to prove that it's genuine. So in Virginia, we have this thing called a self-proving will. So what I told you is true, that for an attested will, you have to have 2 witnesses. That's true. But if you take one more step and then have a notary notarize the will, then it can be a self-proving will, and the witnesses don't have to come down to court and say, yep, that's Claire's signature right there. Okay? So a lot of people have self-proving wills. This next, the last bullet on the slide's on the test, so just in case y'all want to know that the personal representative, that's an executor or an executrix, is allowed to be reimbursed for reasonable expenses, and generally they're entitled to a fee, and that usually is 5% of the value of the estate. All right, so here's Virginia intestate succession. You don't have to know this, I'm just telling you about it. So if there is a surviving spouse, so let's say I die without a will, and all my property goes to my husband. My husband dies without a will, it all comes to me, if we don't have any children. But if we do have children, it's a whole different ball game. So if we do have children, then 1/3 goes to the surviving spouse, and generally 2/3 go to among the other children. Okay, so unless property is, and it wouldn't happen this way exactly if our property is held as tenants by the entirety. So all the property that's held as tenants by the entirety would automatically convey to the surviving spouse. So it wouldn't exactly be that I get 1/3 and the kids get 2/3, because most of our assets consist of real property held as tenants by the entirety. All right, so if they're children or their descendants, 1/3 goes to the surviving spouse. The remaining 2/3 is divided among all the children. And if there's no surviving spouse, all passes to the children and their descendants. And no spouse, no children, it would go to the deceased's father and mother. If none of the above, then it passes to the deceased's brothers and sisters. Anyway, do you have to know this? No, you don't need to know that. Undue influence. This is one of the most commonly used defenses to the validity of a will, is undue influence. And so what you would look at in terms of has someone been unduly influenced is this a person that is susceptible to influence? Are they dependent on another person for their care? Are they, on painkillers? Is there an opportunity to unduly influence the testator? Is the person inclined to exercise undue influence? And then does the will reflect undue influence? So we're going to look at a case that involves a father, a son, and a paramour of the father, who's now deceased, who's been the girlfriend for 2 months, I think it was. And that's the Ramsey versus Taylor case on page 461. I'm just going to call them Senior and Junior. It's for the father and son. So Senior was dying of cancer, and he was on really high doses of morphine, but he was physically active almost until he died. He had consulted with his attorney by himself, and he left his estate to his paramour of 2 months, and Junior challenged the validity of the will. All right, so here's the challenge here. Here are the facts. John Ramsey Sr. executed a will in the last months of his life that left the bulk of his estate to Melody Taylor, his paramour. Senior's relationships with his sons and grandsons were strained, and his will included the following clause: I have intentionally provided significant yet smaller amounts for my son and grandsons because they have for several years alienated my affections by being irresponsible, contentious, and constantly seeking financial support from me rather than providing for themselves. I have made provisions for Melody J. Taylor because Melody J. Taylor provides me care and support. All right, so the question for the court is, was there undue influence in this case? So, Did any of y'all read this one? So let me just tell you what the factors are that the court looked at. The court actually, I'll tell you, cut to the chase. The court said, no undue influence here. And this is what they looked at. They said, first, Senior consulted with his lawyer by himself. So he went to his lawyer to write the second will all by himself. Paramore was not there. Second thing he looked at, the court looked at, they said, well, this was an unnatural disposition of an estate when you leave it to a girlfriend of 2 months. But here's what the court said, that this presumption is overcome because he had previously reduced the amount that he was going to leave to his kid, his child, and his grandsons already. He'd already reduced the amount that he was going to give them. And then the third thing the court looked at, I think it was kind of interesting. They said, Senior was intent on influencing other people with his money and not the other way around. Other people didn't influence him. He influenced others. So they said, no, there's no undue influence here. This is exactly what he wanted to do. And that's exactly what he did. All right, so that concludes the chapter. And so I will see you all on Tuesday. And that's it.